Okay. Wow. All right. We're going to read the California Civil Procedure, California Code of Civil Procedure. We're going to read part 2. We just finished reading part 3. And actually, chapter 3 of part 2. And before going on, I'm going to just highlight what I think it said, which is about the statute of limitations. It's titled The Time of Commencing Civil Actions. So 180 days when there is a trespass underground, like for instance with wells, oil, etc. It's a private action. It's not one that the state has, and thus that's why it's 180 days. There's special ones for some trust in Virginia and 9/11 victims versus terrorists involved, and an earthquake. Not the 9/11 victims refers to section 335.1. There's a 10-year statute of limitations, kind of all over the place. I can't go in order because there was literally so many. The 10-year statute of limitations is for a latent deficiency in construction, and construction is seriously very broad. It has to do with like assessing plans, inspection, everything, and actual construction. So there's a 90-month statute of limitations for goods left at the hospital or a group house or various other places where you stay for medical attention. There's a 6-year statute of limitation after the date of birth for minors for injuries related to childbirth, and for contracts such as a deed of trust, debentures, and bonds that are corporate, like not publicly issued bonds. There's a 5-year statute of limitations for agencies for health and safety and public. I don't even know what that section was called, but there's also a 5-year statute of limitations for basically to redeem your property after an adverse possession. And I think like a breach of mortgage is involved with that. There's a 4-year statute of limitations for leases of real property. And it's also like everything else if it's not stipulated elsewhere. There's a 6-month, it's like a default. There's a 6-month statute of limitations if your action is against an officer to recover goods seized in the officer's official capacity, and to recover from set off like as it pertains to stock, and to invalidate the disassociation of a corporation or formation plus like public entity in districts. And there's a 6-month statute of limitation for the constitutional action against a state or its agencies and commissions, etc., for relating to their funding. And lastly, the 6-month statute of limitations deals with bonds, authorization, sale, and issuance. And this is relating to public bonds. So it's much less than if it's like corporate bonds, which is 60 years. And 3-year statute of limitation deals with trespass, liability from statutes, like being violated, chattel injury or recovery, public bonds again, forestry, fish and game, domestic violence. And 3 to 5 I wrote down for notary malfeasance or misfeasance. And also 3 to 5 years for business professionals regarding environmental health. 2-year statute of limitation for a criminal tort, a contractor relating to real property or lease, civil action for injury or illness based on exposure to hazardous material or toxic substance. And then you have your patent construction deficiencies. And again, that involves like every participant in construction. You have a 60-day statute of limitations after the 60-day notice that you receive for neighborhood improvements by a public entity. There's a 1-year statute of limitations for libel, animal neglect, seduction, and forfeiture. There's a 1 to 4 year statute of limitation for the wrongful act or omission of an attorney, or greater than 4 years. It's like 1 year if it's civil, but it can be greater than 4 years if it has to do with like in showing of an innocent defendant, criminal case, and there might be a required showing of innocence, and it can be told like based on disability. And unlimited statute of limitations is sexual assault, I believe, for a child or covering up sexual assault. And if the person brings the action when they're greater than 40 years old, then they have to like certify, and so does the attorney, regarding collateral evidence or corroborative evidence. And if you don't give that certification, I think it is fatal to the case. And art, if it's less than 100 years old. And bonds and coupons from don't know, an amount due from financial institutions, unless the institution is insolvent and it's being liquidated, in which case the statute of limitations runs from that period, but I believe it's unlimited. So if it's liquidated, I don't think you can recover from it. So anyway, mortgage is unlimited. Consumer debt and settling accounts, that's actually a 4-year statute of limitations. Okay, so that's what we learned in chapter 2. 3, the time of commencing actions other than recovery of real property, which I believe is like 5. Yeah, because that whole section had to do with adverse possession, which is 5 years. So going backward, we're going to now enter into chapter 4, general provisions as to time of commencing action. And hopefully we can have someone else. So we stopped. And that's okay. If a person is held to bring an action or other proceeding, which action or other proceeding has not been filed or otherwise instituted, is represented by an attorney over whose practice of the state has assumed jurisdiction pursuant to 6180 and Section 6190 of the Business and Professions Code, and the application for the court to assume jurisdiction is filed prior to the expiration of the applicable statute of limitation or claim statute, the person shall have 6 months from the date of entry of the order assuming jurisdiction within which to file or otherwise institute the matter, if applicable statute of limitation otherwise would have expired. Six months from the date of entry of the order assuming jurisdiction within which to file or otherwise institute the matter, if the applicable statute of limitation otherwise would have expired. And this is a person entitled to bring an action or other proceeding which hasn't been filed or otherwise instituted, but is represented by an attorney over whose practice a court of a state has assumed jurisdiction pursuant to those sections. Now let's move on to 354. When a person is, by reason of the existence of a state of war, under a disability to commence an action, the time of the continuance of such disability is not part of the period limited for the commencement of the action, whether such cause of action shall have accrued prior to or during the period of such disability. The following definitions give construction of this section. That's entity means any museum or gallery displays, exhibits, or sells any article or historical, interpretive. That's what an entity is. Scientific or artistic significance. And Holocaust era artwork means any article of artistic significance taken as a result of Nazi persecution during the period of 1929 to 1945 inclusive. It's so funny how, like, when a case has international implication, it works its way into statute. Notwithstanding any other provision of law, any owner or heir or beneficiary of an owner of Holocaust era artwork may bring an action to recover Holocaust era artwork from the entity described in paragraph 1 of subsection A, subject to section 410.10. That action may be brought in a superior court of the state, which court shall have jurisdiction over the action until it is completed, completion or resolution. Section 361 does not apply to this section. Any action brought under this section shall be dismissed for the failure to comply with the applicable statute of limitations if the action is commenced on or before December 31st of 2010. 354.4a, the following definitions govern the construction of this section: Armenian genocide victim and insurer. I'm not going to define those, but it's interesting because it's like the Ottoman Empire during the period of 1915 to 1923, and the insurer is that one. It's pretty basic. They satisfy the constitutional requirements for jurisdiction that's a life, property, liability, health, annuities, dowry, educational casualty, or other insurance covering persons or property to persons in Europe or Asia at any time between 1875 and 1923. Notwithstanding the provision of law, any Armenian genocide victim or heir or beneficiary of an Armenian genocide victim who resides in the state and has a claim arising out of insurance policy or policies purchased or in effect in Europe or Asia between 1875 and 1923 from an insurer described in paragraph 2 of subsection A may bring a legal action or may continue a pending legal action to recover on that claim in any court of competent jurisdiction in this state, which court shall be deemed the proper forum for that action until the completion of resolution. Any action, including the pending action brought by the Armenian genocide victim or heir, beneficiary of the Armenian genocide victim, whether resident or non-resident of the state, seeking benefits under the insurance policies or in effect between 1875 and 1923, shall not be dismissed for failure to comply with the applicable statute of limitations, provided the actions filed before December 31st of 2016. The provisions of this section are severable If any provision of the section or its application is held invalid, the invalidity shall not affect other provisions or applications that can be given without the invalid provision or application. Section 355.45. For purposes of this section, it's about Armenian genocide victims and relates to banks and deposit assets and looted assets. I don't think I'm going to have to read the definitions for that, but it says the court shall be deemed the proper forum for the action until its completion or resolution, if that all took place, and any action, including any pending action brought by such a victim or heir or beneficiary of this victim who resides in the state seeking payment or return of deposit assets or return of looted assets shall not be dismissed for failure to comply with the applicable statute of limitations if the actions filed on or before December 31st, 2016. The provisions of the section are severable like before. 354.5, the following definitions govern the construction of this section, and we're talking about Holocaust victims and related company, which means a parent, subsidiary, reinsurer, successor in interest, managing general agent, or affiliate company of the insurer. Insurer means an insurance provider doing business in the state or whose contracts in the state satisfy the constitutional requirements jurisdiction for the jurisdiction and sold life, property, liability, health, annuities, dowry, educational, casualty, and insurance covering people or property to persons in Europe at the time before 1945, directly or through a related company, whether the sale of the insurance occurred before or after the insurer and the related company became related. Notwithstanding any other provision of law, any Holocaust victim or heir or beneficiary of a Holocaust victim who resides in the state and has a claim arising out of insurance policy or policy is purchased or in effect in Europe before 1945 from an insurer described in paragraph 3 of subdivision A may bring a legal action to recover on that claim in the superior court of the state, which the court shall be vested with jurisdiction over that action until its completion or resolution, as long as shall not be dismissed for failure to comply with the applicable statute of limitations, provided it's commenced before December 13th of 2010 or 31st of 2010. Section 354.6, as used in this section, the Second World War slave labor victim is defined, and it has to do with Nazi regime. Second World War forced labor victim and compensation to such that individuals that should have been paid for damage and damages for injuries sustained in connection with the labor performed. Present value shall be calculated on the market value of services at the time they were performed, plus interest from the time the services were performed, compounded annually to date of full payment without diminution for wartime or post-war currency devaluation. So it's saying that these victims can bring an action against what they define as, entities or successor in interests, subsidiaries or affiliates. That action can be brought in a superior court in the state, which court shall have jurisdiction over the action until it's completed. Any action brought will not be dismissed or failure to comply with this SOL if the action is commenced before December 31st, 2010. Then there's 354.7, and the following definitions govern the construction of this section. A bracero means any person who participated in a labor importation program known as the Bracero program between January 1, 1942 and January 1, 1950, pursuant to the agreements between the United States and Mexico. Before I read all of this, I'm just going to say, if it's filed before December 31st, 2005, and at the beginning of this section, we were talking about the date of the complaint is what again? 350. An action is commenced when the complaint is filed. So you're probably going to have somebody coming in that's like with an appeal from something like this. So I'm going to kind of move a little bit quicker through this stuff. All right, so brass arrows, moving along, because you would have to have an action filed before December 31st, 2005. Notwithstanding any law, including but not limited to Section 335.1, the following action shall be commenced within 10 years. An action for assault, battery, or both, where the conduct constituting the assault or battery would also constitute the following: an act of torture, an act of genocide, a war crime, an attempted extrajudicial killing, and crimes against humanity. So, they all point to they don't all point to the penal code. The first one points to the penal code. Then there's the United States Code for genocide, war crime, and public law for extrajudicial killing and crimes against humanity. We break that down for purposes of this paragraph. That means any of the following acts as part of widespread or systematic attack directed against the civil population with knowledge of the attack: murder, extermination, enslavement, forcible transfer of population, arbitrary detention, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or other form of sexual violence of comparable gravity, persecution on political, race, national, ethnic, cultural, religious, or gender grounds, enforced disappearance of persons, other inhumane acts of similar character, intentionally causing great suffering, serious bodily injury, or serious mental injury, and action for wrongful death where the death arises out of. So we just skipped out crimes against humanity, and we're talking again. There's the 10-year statute of limitations. 2, an action for wrongful death where the death arises out of conduct constituting any of the acts described in the 1. Okay, so in the 10-year section that I have written in my notes, we have, latent deficiency in construction, but let's add like crimes against humanity, war crimes. And now we're talking about wrongful death. Wow, that's a long time. An act of taking property where the death would constitute an extrajudicial killing. Okay, so wrongful death and extrajudicial killing. So I don't know if they're talking whatever. And I'm not going to assume here. An action for the taking of property in violation of international law in which either of the following apply: the property or any property exchanged for such property is present in the United States in connection with a commercial activity carried on by the United States in the United States by a foreign state. That property or any property exchanged for such property is known or operated by an agency or instrumentality of a foreign state, and that agency or instrumentality is engaged in commercial activity in the United States. 4th, an action seeking benefits under an insurance policy where the insurance claim arises out of any conduct above. An action brought into the section shall not be dismissed for failure to comply with oops. An action brought in this section shall not be dismissed for failure to comply with the previously applicable statute of limitation. Section 361 shall not apply to an action brought pursuant to this section. And 361 is going to come because we're in like 354 or something right now. Concerning an act, so where were we? 361 shall not apply to an action brought pursuant to this section if all or part of the unlawful acts or acts out of which the action arise occurred in the state. A prevailing plaintiff must be awarded reasonable attorney fees and litigation costs, including but not limited to expert witness fees and expenses as part of the costs. This section shall apply to all sections commenced concerning an act described in paragraphs 1 through 4 inclusive, and subdivision A that occurs on or after January 1, 2016. The provisions of this section are severable. If any provision of this section or its application is held invalid, that invalidity shall not affect other provisions or applications that can be given effect without the valid provision or application. If an action is commenced within the time prescribed therefore, and the judgment therein for the plaintiff be reversed on appeal other than on the merits, a new action may be commenced within 1 year of the reversal. Reversed on appeal. A new action must be commenced within 1 year. So that's 355. I don't know how to write this down. No person. So 356 is when a commencement of an action is stayed by injunction or statutory prohibition. The time of the continuance of the injunction or prohibition is not part of the time limited for the commencement of the action. No person can avail himself of a disability unless it existed when the right of action accrued. That's 357. 358, when 2 or more disabilities coexist at the same time, the right of action continues. The limitation does not attach until they are removed. 359, the title does not affect actions against director, shareholders, or members of a corporation to recover a penalty for forfeiture imposed or to enforce a liability created by law, but such actions must be brought within 3 years after the discovery by the aggrieved party on the facts upon which penalty of forfeiture attached and a liability was created. So in 3 years, when we're going to talk about forfeiture by directors, did it say officers, shareholders, and members? If the obligations under surety bonds are conditioned upon, this is 359.5, if they're conditioned upon performance of the principal, the expiration of the statute of limitations with respect to the obligations of the principal, other than the obligations of the principal under the bond, shall also bar an action against the principal or surety under the bond unless the terms of the bond provide otherwise. 360, no acknowledgement or promise is sufficient evidence of a new or continuing contract by which to take the case out of the operation of this title, unless the same is contained in the same writing signed by the party to be charged thereby, provided that any payment or account of principal or interest due on the promissory note may be made by the party to be charged shall be deemed a sufficient acknowledgement or promise of a continuing contract to stop from time to time at any such payment is made, the running of the time within which an action may be commenced upon the principal sum or any installment of principal of interest due on such note, and to start the running of a new period of time, but no payment of itself shall revive a cause of action once barred. No waiver shall bar a defense to an action that the action was not commenced within the time limited by this title unless the waiver is in writing and signed by the person obligated. No waiver executed prior to the expiration of the time limited for the commencement of the action by this title shall be effective for a period exceeding 4 years from the date of expiration of the time limited for commencement of the action. But this title and no waiver executed after the expiration of such time shall be effective for a period exceeding 4 years from the date thereof, but any such waiver may be renewed for a further period, if not exceeding 4 years from the expiration of the immediately preceding waiver. Such waivers may be made successively. The provisions of this section shall not be applicable to any acknowledgement, promise, or any form of waiver which is in writing and signed by the person obligated to be given to any county to secure repayment of indigent aid or the repayment of monies fraudulently or illegally obtained from the county. 361, when a cause of action has arisen in another state or in a foreign country by the laws thereof, and action thereon cannot there be maintained against a person by reason of lapse of time, a action thereon shall not be maintained against him in this state except in favor of one who has been a citizen of the state and who has held the cause of action the time it accrued. This title does not extend to actions already commenced, nor to cases where the time prescribed in any existing statute for acquiring a right or barring a remedy has fully run. But the laws now in force are applicable to such actions or cases and are repealed subject to the provisions of the section. The word action is used in this title is to be construed whenever it is necessary to do so, as including a special proceeding of a civil nature. So, So there's a lot to write down that I just saw, and it's like, so chapter 4 says like an action is commenced at the time of the complaint. It also gives additional statute of limitations, and then it starts going into like you can SOL tolling can be waived, but like it can't be bought. I'm just combining like two sections here, and there's that foreign aspect there. There's the surety bonds. Okay, I wrote that down. No person can avail. Okay, so this also talked about disabilities tolling, which is actually important. And how SOL is not applicable to pending actions and like reversals and appeals. There's one more thing. It's like they were talking about injunction. They're talking about interlocutory BS. So since I don't, and then there was something in there about attorney fees. So you always want to write that down. Attorney fees for like really bad stuff. Expert fees. Paid by the what? I don't care. I'm going to move on to the next chapter. 5. The commencement of actions based upon professional negligence. Actually, yeah, that's chapter 5. So we're going to let someone else read this part. Stop talking again. All right, so maneuver. Maneuver. What's the deal? This section is important, and I haven't really been listening to it. Oh, it's over already. So we're talking about healthcare professional negligence at first. At least 90 days prior notice of intention to commence the action. All right. So you need prior notice for healthcare providers' professional negligence. No particular form of notice is required, but it shall notify the defendant of the legal basis of the claim and the type of loss sustained, including the specificity and the nature of the injury suffered. The notice shall be served in the manner prescribed in Chapter 5. Okay, so no particular form of notice except for what says in Chapter 5. If the notice is served within 90 days of the expiration of the applicable statute of limitations, the time for the commencement of the action shall be extended 90 days from the service of the notice. The provisions of this action, that's interesting, shall not be applicable with respect to the defendant whose name is unknown. And then for purposes of the section, we define healthcare provider and professional negligence, and the failure to comply with this chapter shall not invalidate the any proceedings of the court and nor shall it affect the jurisdiction of the court to render a judgment therein. However, failure to comply with such sections by an attorney of law shall be grounds for professional discipline, and the state bar shall investigate and take appropriate action if any such case is brought to its attention. Weird. All right, so we're going to the last chapter in this part, which is Chapter 6, time of commencement of action after a person's death. We're going to hope this isn't terribly long. Not. Interesting. It just went right back. Just moved back. And then 366.3A, if a person has a claim that arises from a promise or agreement with a decedent for distribution from an estate or trust or under another instrument, whether the promise or agreement was made orally or in writing, an action to enforce the claim to distribution may be commenced within 1 year after the date of death, and the limitations period that would have been applicable does not apply. The limitations period provided in this section for commencement of an action shall not be told or extended for any reason except for as provided in sections 12, 12A, and 12B of this code, and former Part 3, commencing in section 21300 of Division 11 of the Probate Code, as that part read prior to its repeal by Chapter 173 of the Statutes of 2008. And C, this section applies to actions brought on claims concerning persons dying on or after the effective date of this section. So that's part 2 of part 2. So I'm going to end this stream. We'll do part 3 another time.